Prynhaddad, diolch yn fawr o dod. Good afternoon, thank you for coming. My name is Richard Booth. I'm a barrister in the chambers of Philip Havers QC at 1 Crown Office Row in the Temple in London. I'm going to talk about careers in the law, but I'd like to give you a bit of a personal story first of all. Picture the scene. It is 1979. A 10-year-old boy from Cwmbran is really enjoying a new US courtroom TV drama. It's about an attorney who is brilliant at questioning witnesses, but has a slightly chaotic personal life and is forever building a half-finished house. The boy thinks he would like to stand up in court, argue legal cases, and question witnesses as a job. So he asks a few questions, does a bit of reading, and finds out that barristers are the specialist court advocates in England and Wales. He decides that he wants to be a barrister. Fast forward 14 years. It is October 1993. The incredibly lucky boy who wanted to be a barrister has studied in Monmouth, in South Africa, in Cambridge, and in Brussels. Has played lots of rugby. In fact, unbeknown to him, he just played his last match. Has learned to speak reasonable French and Spanish, and has been going out for the previous 4 years with a gorgeous girl also from Cwmbran. Tonight he is being called to the bar by Middle Temple, his inn of court, under the hammer-beam ceiling where Twelfth Night was first performed. He has just started his pupillage at 1 Crown Office Row. Fast forward another 20 years. It is the very cold spring of 2013. The remarkably lucky boy, now married to that same girl for 18 years and with 2 cheeky kids, is dressed in tights, breeches, patent buckled shoes, a jabot, I'll explain what one of those is later, a rosette, a waistcoat, a frock coat, a silk gown, and a full-bottomed wig. Astonishingly to those who know his dress sense, this outlandish form of costume, thought by some to be mourning for Queen Anne, is not purely out of choice. Rather, it is a required ceremonial kit for the newly appointed Queen's Counsel, or QC, who is about to be sworn in by the Lord Chancellor in the freezing Great Hall of the Palace of Westminster, and later that same day, called to the front row of the court by the Lord Chief Justice, the aptly named Lord Judge. I am that lucky boy who took silk, so called because of the silk gown, in 2013. The appointment as Queen's Counsel is a mark of excellence in advocacy. I've been treading the boards of courts and tribunals all over England and Wales for the past 24 years, initially doing a little bit of almost anything in front of old school gruff judges, but specialising in recent years in all aspects of healthcare law, in particular clinical negligence and regulatory and disciplinary law. Now, we're going to cover today myths about the bar, what a barrister actually does, and also talk about a bit about what a solicitor actually does, the route to becoming a barrister or solicitor, and where to go for further information. Now, the law permeates all of our lives. Today's Times has, I picked up 6 articles of possible relevance to lawyers, starting with the back page, first of all, the Sam Warburton exclusive interview with Steve James. Sam Warburton saying, lengthening the rugby season will put players at greater risk of injury. I've been involved in some cases already involving concussion in rugby and possible mismanagement of concussion by club doctors. It's a hot topic. On page 4 of the Times, a story about a coroner holding that an NHS trust's failures could have led to the murder of a man in Poundland in Abingdon by a schizophrenic who should have been looked after properly. On page 12, Baroness Hale, the President of the Supreme Court, has backed the removal of veils by witnesses in trials, citing Quranic sources in support of her view. On page 16, parents lose their fight in the Court of Appeal to keep their baby son on life support. A very sad case indeed. Also on page 16, a rugby league star jailed having been tasered 6 times by the police in a street battle. And lastly, on page 17, Paul Flowers, former chairman of a cooperative bank, banned by the Financial Conduct Authority from working in financial services. All of those are cases with which lawyers get involved, and the law gets involved with many aspects of our daily life. Now, some myths are up on the screen at the moment about what barristers are. The bar has changed a lot since I started at the bar, and the bar, I think, is now much more representative of society than it was. It's still not perfect. There are about 16,000 barristers in private practice in England and Wales, and of those, there are about 6,000 women. So it's not 50-50 yet, although of those coming into the profession, it is absolutely 50-50. We don't spend all of our time in court. Lots of us have to do quite a lot of paperwork. I've known at least one barrister describe being at the bar as having homework for life, because you always have the next set of papers to do for the next deadline. And we don't see it as a game. It is a great privilege to represent people, but very far from a game. So what is a barrister? A specialist legal advisor, certainly, and we have to advise on paper and orally in conference, meeting clients as to the strengths and weaknesses of a case. Work involves certainly standing up in court and being an advocate, but also advising on paper and drafting court documents called pleadings, which have to be put in quite formal language. We're also involved in training junior entrants to the bar. Just to tell you a little bit about my background, I was born in what's now the Celtic Manor Hotel in Newport, when it was a maternity hospital. I grew up in hotels, clubs and pubs. That's what my parents ran. I had no family connections to the law whatsoever, save for a late grandfather who had been a sergeant in the Monmouthshire Constabulary. So, without legal connections, as a 10-year-old deciding I wanted to pursue a legal career, what did I do? Well, I was lucky. I had great encouragement from my parents. They never pressured me, but they encouraged me basically to aim as high as possible. And also, I had inspirational teachers, both at Greenmeadow Primary School in Cwmbran, and then later at Monmouth School, to where I won a scholarship. Subjects. People often ask me about subjects. What subjects should I study if I want to be a lawyer at school? For those of you in Year 9 about to choose your GCSEs, it doesn't matter too much. What I always say to people, whether it's GCSEs or A-levels or other courses, choose subjects which you enjoy, because then you'll be better at those subjects, you'll work harder at them, and you'll get better results. When you get to A-level, try to avoid too many subjects that are totally new to you. Often it's better to stick with at least 2 that you've done before, and try to avoid subjects which sound a bit off the wall. The law is still quite traditional in many ways, and so if you're choosing 3 subjects which don't really seem to hang together as proper academic subjects, that may pose problems further down the line. At A-level, I did Spanish, French, Latin and history, but equally I know barristers who did maths, physics, chemistry and biology. It really does not matter. I applied to Oxford to study law, but was rejected. That was the first big disappointment that I had academically, and yes, it was quite a blow, but again, I was lucky to have huge support from my teachers who encouraged me to press on and still aim high. I ended up applying after my A-levels to Cambridge to read French and Spanish, and I was accepted. All through that time in school, I had this ambition of being a barrister, which is, I know, slightly unusual. Many of you may not have thought what you want to do, but I was able to choose my subjects with a view to pursuing that career. We'll come back to barristers and solicitors in a moment. I had a gap year because I'd had to apply after my A-levels, and I was lucky enough to win a scholarship to attend a school in South Africa for 6 months. This was 1988, and apartheid was still in place, an appalling system which I got to see firsthand. It was an amazing experience to have the opportunity to spend 6 months in such a country, I got to travel around and got quite involved in student politics. If any of you is thinking about having a gap year, I'm acutely conscious that because of student fee issues now, it's becoming ever more difficult to justify. But if you are thinking of having a gap year, I would encourage you to apply for it, to look early for scholarships that are available, because they are out there, and to make sure you have sufficient structure. Don't simply go travelling, but actually have a plan as to how to make the most of your time. Getting to Cambridge, I attended a college called Fitzwilliam College. Now, if you look at pictures of Fitzwilliam College, it does not look like your impression of a Cambridge college. It was built mainly in the 1960s, with lots of additions since. Fitzwilliam has a greater than 70% state school intake. When I went, there was a strong northern bias, but also a healthy Welsh contingent. We had the best football team among the colleges in Cambridge. I did 1 year of Spanish and French, and then changed subject and did 2 years of law. I played lots of sport, again got involved in student politics, and really tried to make as much of the opportunity the university offered as I could. Thankfully, at the end of my 3 years, I ended up with a 2-1, and that is really a prerequisite now if you want a successful legal career, whether as a solicitor or a barrister. Having been a linguist originally, lots of my friends were abroad in my final year, and so I had the travel itch, so I hunted high and low for another chance of a scholarship abroad. I managed to get one to the French-speaking university in Brussels to do a master's in European law. And when you go to study in continental Europe, you thank your lucky stars that you were educated here, because their syllabus system is very different from ours. There were awful oral exams at the end of that course, all conducted in French, at the end of which the examiner would give you a mark. And so very scary indeed. But the overall experience was a great experience culturally, with a real mishmash of people from around the world. So, barrister as against solicitor, what's the difference? Well, I often describe it as the difference between a consultant and a GP. If you have a medical problem of any sort, you go to see your GP. If you have a general legal problem, you go to see your solicitor. Most of the time, the GP can deal with your medical problem, does not need to refer you on to a consultant. Most of the time, the solicitor can deal with your legal problem. Again, does not need to refer you on to a barrister. But occasionally, the solicitor will need either advice from a specialist on a particular area of law, or will need a specialist advocate, in which case they instruct us, and that's how we come into it. Various different terms are used. It's a lot of jargon involved in the law. Call. I was called to the bar in 1993. So if you were talking about someone's call, someone of 10 years call was called to the bar 10 years ago. A junior barrister. You can have some very old junior barristers. You can have junior barristers who are in their 70s. It's simply distinguishing between a barrister who has not yet taken silk. QCs, Queen's Counsel are referred to as silks, the rest of the bar referred to as juniors. Self-employed barristers. I am a self-employed barrister, and all barristers in private practice in England and Wales are self-employed. There is a separate section of employed barristers, probably about 3,000 employed barristers, and they can be doing all kinds of work for actually as employees for organisations. They each have their own benefits and downsides. As an employed barrister, you get a salary every month. A self-employed barrister like me, you don't get a salary every month. You have to wait for the solicitors to pay you, and sometimes it can be quite a long wait, though again that has improved a lot in recent years. Chambers. What are chambers? I told you at the start I'm a member of chambers at 1 Crown Office Row. Essentially, chambers are the way in which barristers organise themselves, self-employed barristers gathering together, sharing their costs of their clerks, their secretarial costs, their rent costs, and we pay a percentage of our income to chambers to fund those central costs. Circuits. There are different circuits of barristers around England and Wales. There is the Wales and Chester Circuit, of which I'm a member. You have the South Eastern Circuit, South East of England, the Western Circuit, North Western, North Eastern, and the Midland Circuit. So essentially, again, ways in which barristers align themselves depending on geography. And the specialist bar associations, depending on the kind of work you're doing at the bar, you're a member of a particular bar association. I'm a member of the Professional Negligence Bar Association, among others. In terms of what skills you need to become a barrister, I came back from Brussels after my master's to do what was then called the Bar Vocational Course, now the Bar Professional Training Course. And then there was only one place you could do it, the Inns of Court School of Law. And there were 1,050 of us doing that course in that one institution. Now you can do it at a number of institutions, but there are very many more students, probably 1,500 plus each year doing the bar course. The competition is very fierce. But as regards skills, you've got to love language and enjoy use of language, both written and oral. You've got to be numerate. Just because you're a lawyer doesn't mean you're not involved in sums from time to time, calculating damages which are due to people, sometimes all kinds of strange calculations you have to perform during cases. Obviously, you've got to be analytical. Obviously, you've got to be able to get on with people. I think interpersonal skills are much underappreciated. They're very, very important. Some IT skills, you're working on your own quite a lot, so you've got to be able to organise yourself. A good memory is very helpful indeed. And also the ability to remain detached, professional and discreet. Confidentiality is key. You've got to be able to think logically, and also stress and the pressure can be quite significant, so you have to have ways of coping with that. There are 3 stages currently to qualify as a barrister. The academic stage, your degree. Now, one thing people often ask me, do I need to study law to be a solicitor or barrister? Short answer, no, as a degree. You can do a degree in law or not in law. If you do it in law, you save yourself 1 year of study. But if you do a subject other than law, you can do the law conversion course, now known as the GDL, the Graduate Diploma in Law, in 12 months, and you do all the subjects needed to exempt you from further study at the academic stage. And so, for example, in chambers with me, I have colleagues who studied history, zoology, classics, science subjects, so at degree level, and have then gone on to be barristers. So it really does not matter. Again, studying a subject you like can often be better. Law students as undergraduates have to work quite hard. They work as hard as the medics at university, and so sometimes if you're doing history, maybe having to provide 2 essays a fortnight, then that's a lot lighter workload than the law undergraduates have. The vocational stage, the Bar Professional Training Course, that's another year. You have to do it. You can't get around it. If, of course, you're going down the solicitor's route, you have a separate course which you do again in a year. And then as a barrister, you then attempt to get pupillage. And this is the great pinch point at the bar, because obtaining pupillage is very, very difficult. When I was at bar school, there were about 1,050 of us competing for about 700 pupillages. Now, you've got about 1,500 per year on the bar course, competing for about 400 pupillages per year. And it's not simply 1,500 applying, because there are those who've qualified in the previous 5 years and not got pupillage applying as well. So the odds of getting pupillage are not strong. And these courses are expensive, and so it can be very tough indeed. In terms of the Inns of Court, some of you may have heard of the Inns of Court. The sharper-eyed among you will spot that the Bar Council have chosen to put the Hogwarts logo, Draco Dormiens Nunquam Titulandus here. The inns are a bit like stepping back in time. In essence, these are the places where the barristers gather together to educate themselves and each other back in the day. But the 4 of them have survived. There used to be more than 4. And the 4 that have survived are Lincoln's Inn, Gray's Inn, Middle Temple and Inner Temple. I'm a proud member of Middle Temple. As I said at the start, I was called to the bar by my inn, Middle Temple, back in 1993. The inns collectively, their most important role in many respects is providing scholarships for students. And the 4 inns provide around £5 million worth of scholarships per year to students. So again, if you're coming down the route to the bar, it's well worth investigating applying to an in for scholarship. You can only apply to one, unfortunately. Dinners. I had to eat 24 dinners in Middle Temple before I could be called to the bar. Now students only have to eat 12. Sometimes if they do a course, they can get away with 8 or 9 rather than 12. The dinners started off because barristers used to be lectured to while they were dining in their inn. The dinners are great occasions for meeting senior members of the inn, who may be judges or senior barristers, but also getting to know your fellow students. The inns provide excellent advocacy training, both in this country and sometimes abroad. They run mooting competitions. Mooting is a kind of legal debating where you, in effect, argue legal cases and provide lectures and social events. And so people tend to be quite attached to their inn. I know you're not at university, any of you yet, and so these next 3 slides won't necessarily add too much, but in essence, it's looking at a way to try and find out as much about the law as you can. I would encourage all of you at school, as long as you're over 14, you can go and sit in the public gallery of any court, whether magistrates court, county court or crown court, as local to you as possible. And that's a good way of seeing at first hand what lawyers do in court, both solicitors and barristers. In terms of work experience, if you are thinking about a legal career, I remember my first work experience was with the Gwent Probation Service, just in Pontypool, and it was a great week. I spent a couple of days in Newport Crown Court, a couple of days working with those trying to rehabilitate offenders. I think obtaining that work experience in the current climate would be far harder, but the place to go and apply is local solicitors' firms, because often it's good just to get a feel for your local high street solicitors and the range of work that they do. Sometimes there are in-house law departments within companies as well, which can offer similar opportunities. You'll see the reference to marshalling. Marshalling is, in effect, work experience with a judge. And again, there are schemes where you can be a judge's marshal for a week, sitting with the judge and essentially discussing cases with the judge. Obviously, confidentiality applies. Things you can do at school, though, already, public speaking and debating are really good ways of finding out whether you think you might be suited for a career as a barrister. Again, this goes through university here, so probably not as relevant to you as it would be. There are certain deadlines as to when you need to apply for different courses. Lots of legal careers fairs go on, and some pupillage fairs. Work experience when in the summer holidays of university is a very big thing now, and many solicitors' firms offer internships in their firms, often for 2 to 4 weeks. But obtaining those internships is very competitive. You have to make sure you hit the deadlines, complete horribly long application forms and applying for them. But again, if you're committed, very well worth doing, because if you've done an internship in a firm and you impress them, you're more likely to have a chance of being offered a training contract by the firm later on. And in terms of the timings and deadlines, again, those are all changing. So don't stand by the deadlines set here. They may not be accurate. I said at the start, you need a 2-1 in your degree, and that is pretty much it. If you do not get a 2-1, then your chances of becoming a barrister or solicitor will be very much reduced. The Bar Professional Training course, I've spoken about the numbers a bit. What do you learn on it? Well, they teach you advocacy skills. You have to video yourself as an advocate, negotiation skills, conference skills, and some law and procedure as well. But in many ways, pupillage is when you really learn, because pupillage is a bit like an apprenticeship. You are accepted as a pupil in chambers. My chambers, 1 Crown Office Row, currently takes 2 pupils a year for 12 months each. And the first 6 months is shadowing your pupil supervisor, having a go at their paperwork, watching them in court, hopefully watching other members of chambers in court, and improving your style of advocacy as a result of watching other people. Then the second 6 months, lots of pupils, current pupils, second sixes, will be starting very shortly, next week. and so they'll be very excited about their first cases in court. I was speaking to one current pupil on Monday night who has already got 2 hearings in his diary for his first week as a second six pupil. I think his first hearing is going to be in Brighton County Court. And so that great nervous excitement you feel. I remember vividly my first appearance in court. It was Easter Tuesday of 1994. I had to travel up to Chester for a hearing all about carriage of goods by road, contract dispute. I remember the district judge saying to me at the end of the hearing, this case didn't need a barrister from London, the local solicitor could have done it. I felt absolutely crestfallen, had to travel back on the bank holiday train thinking, well, this is awful, this is a grim way to start, but thankfully things got better after that. Towards the end of your pupillage, you hope that your chambers will offer you what's called a tenancy. And a tenancy is in essence the opportunity to stay in those chambers as a self-employed barrister, a corner of chambers where you can buy a desk and perch and do your work, and that work will come to you through the chamber's clerks. If you don't obtain tenancy, then you can apply for what's called a third 6 months of pupillage in another set of chambers. And again, the competition is still pretty fierce at that stage. Typically, we take 1/3 6 pupil a year, and they are almost universally very good quality. And so that's pupillage. In terms of the way pupillage works, pupils now have to be paid a minimum of £12,000 for their pupillage year. That is not a lot. My chamber's pupillage award is well north of £50,000 for the year. But chambers vary as to what they offer to their pupils. But you have to bear in mind that often that award is made available in the bar professional training course year as well. And so there are some funds for that quite often. And also you have to bear in mind that very often your first year in actual practice, you'll be earning less than you received by way of a pupillage award. So, how to make yourself stand out? The academics speak for themselves. You do need excellent academic grades, but we bear in mind that each one of us develops at different rates. Not everyone is a star at school. Some only really develop academically later on. So there are different rates, and people are called to the bar at different ages. We do get quite a few mature applicants now. Do work experience, show a genuine interest in the subject. Make sure you get involved in debating. When at university, have a go at mooting if you're studying law, but also maintain your extracurricular activities. We all want to work with people who have interests outside the law, because otherwise it would be a very dull job. And so it actually brings something of yourself if you've got lots of other interests outside the law. Commitment and dedication, again, speak for themselves. You need those just to get through the applications process right at the start. Some scary statistics. Yes, some universities receive up to 30 applications per place for their law degrees. So again, another reason why applying to study law as an undergraduate may not be the best option. The bar professional training course can cost up to £19,000 for the year. It's absurdly expensive and a bit of a scandal, really. And each chambers receives up to 450 applications each year for its pupillage places. The figure varies, but the competition is incredibly intense. Competition to become a solicitor is really no less intense in many ways, but there are more solicitors. And so just simply on the stats, you have got more of a chance. If we look at earnings, I've talked about the pupillage position already. The figure in the second box there, gross earnings, that's before tax, before chambers expenses, of between £30,000 and £1 million a year. There aren't that many barristers earning more than £1 million a year. There are quite a lot who earn close to £30,000 a year. Those working in publicly funded areas of law, so criminal law, family law, where legal aid has been cut very badly in recent years, often struggle. And a number of my contemporaries who went to be criminal barristers did it maybe for 8, 9, 10 years and then realised that they couldn't survive on their earnings, and so went to work in an employed job with a regular salary coming in. Clearly, it is a job where you can be lucky and you can earn a lot, but equally, it's not the picture that every barrister is earning a fortune. And generally, depending on your seniority and the kind of work you're doing, you'll have an hourly rate, and also you get paid what are called brief fees for your court appearances. But we pay, as I said, a percentage of our income to chambers to support the rent and the shared employment costs of our clerks. I've talked about clerks a little bit. There aren't just barristers and solicitors in the law. Our clerks tend to be non-legally qualified, and they essentially are very important people in our lives. They look after our diaries, our court bookings, they attract work in for us, and they negotiate our fees. So it's important for a young barrister to get on with his or her clerks, because they can make or break your career. Now, there are lots of sources of further information, lots of websites you can look at. The inns are very good for information as well. So that's all kind of a general picture. What do I do? What's my work at the bar? Well, medical negligence is what I've come to specialise in, and probably 85% of my work is in medical negligence. I act for both sides, about 50-50. So 50% for claimants, those who've been injured, and 50% for hospitals or doctors, NHS trusts or local health boards, those who are alleged to have been negligent. It's really interesting work. It's a huge variety. I get to meet all kinds of people, and often it's very intellectually stimulating, because you have to get your head around the medicine, but also the law and the challenge of cross-examining experts in these fields is quite stimulating as well. As I said at the start, when I started off, I really did do a bit of everything, from criminal law in the magistrates' court to employment law to divorce cases, matrimonial finance, child contact cases, really a little bit of everything. But over the years, most of the time, most barristers and solicitors hone down to a particular specialism, and that's the subject which that they become known for. I want to say a few words at this point about a scheme some of you may be interested in. I think it will appeal probably most to those in years 9, 10 and 11. This is the Lord Edmund-Davies Legal Education Trust, known as LEDLET for short, which runs a summer scheme in London each year, usually in mid-July, for a week for young Welsh students, typically at the end of the first year of sixth form, to come up and spend a week in legal London. Again, it's a competitive scholarship. You have to apply, and the closing date for 2018 has gone already. But it's named after Lord Edmund-Davies, who came from Aberdare, worked very hard, got a lot of scholarships, and ended up as one of the law lords. The law lords are no more. We refer to them as the justices of the Supreme Court now. So Lord Edmund-Davies seemed like an appropriate person to name the charity after. And there are scholarships available to students to apply to come and spend a week in legal London. And the motto of the trust is Aim High. 49 applicants back in 2017. I'm not sure how many there have been this year, 2018. I suspect about the same or a few more than that. 10 are chosen, spent a week in London, most staying in Gray's Inn, one of the inns of court, meeting lawyers, getting involved in debating, meeting the Solicitor General, Robert Buckland, QC, who's a Llanelli native. The students really enjoy the experience. They spend a day with a firm of City of London solicitors, a day with a barrister, usually a day with a judge, and they get to go to various receptions for them as well during the week. It is a great experience. I encourage as many of you as possible to look up LEDLET and to apply for such a scholarship if you're interested in pursuing a legal career. Yes, that's a little bit more about the time with LEDLET. The ALWL, Association of London Welsh Lawyers. There are lots of Welsh lawyers in London. I think there are probably more than a proportionate representation of Welsh lawyers in London. But we tend to get together and try and make sure that our presence is felt. Of course, the bar is not just in London. About 2/3 of barristers in self-employed practice are in London, but the rest are spread around the country. So you've got sets of chambers in Cardiff, Swansea, Bristol, Manchester, Leeds, Exeter, Nottingham, Birmingham, Newcastle, Liverpool, lots and lots of major cities, and court centres in most of those cities as well. So it isn't totally London-centric, but this scheme provides a week in legal London. So there's Lord Edmund-Davies himself in his younger years at the bar. I've talked about clerks. I haven't talked about legal executives. Legal executives are neither solicitors nor barristers and tend to have come to work at the age of 16 or 18 in a law firm and then done the legal executive qualifications when they're working at the law firm. But legal executives can rise to high positions of responsibility. I know one legal executive who has been head of a personal injury team in a large law firm. So there are non-traditional routes into the law. And it's interesting that the Law Society is thinking about at the moment reintroducing some form of apprenticeship scheme, in effect, to qualify as a solicitor without actually pursuing a degree first. That, I think, is still in the pipeline, but may well be coming through shortly. Just to give you a snapshot as to my practice over last week and this week, just to try and give you a feel for the way in which self-employment works for me. A week last Monday, 26th of Feb, that was the day on which the new QCs, the 2018 QCs, were sworn in. So we had 2 new QCs in my chambers. Always a lovely day. Their families come in for the ceremonial part of the day, and members of chambers gather together to welcome them. And there were a couple of QCs in other chambers whom I knew as well, who I was able to go and congratulate that day, fitting in my paperwork around it. Tuesday the 27th, I had a case conference where I act for a girl who suffered traumatic brain damage from skull fractures during an emergency cesarean section performed by junior doctors. That's a case in which we've managed to settle the issue of liability, but damages are still to be settled. Wednesday the 28th, I was working on my papers, advices and pleadings at home. Again, a feature of the bar. Sometimes, as long as your clerks are understanding, you can work from home from time to time. Followed by going into chambers for a chambers meeting where we took the happy decision to offer tenancy to our third 6-month pupil. Then Thursday the 1st of March, I participated in the mediation in a clinical negligence case where I act for a defendant NHS trust. The hospital had performed unnecessary surgery on a middle-aged lady. It went wrong and left her doubly incontinent with grim personal consequences. The case didn't settle at the mediation. The parties remain quite a long way apart, £1.5 million apart, in fact, but the case goes to trial next month. And then on Thursday night, I attended the Wales in London St David's Day dinner at the Guildhall in London. This year, the president was another Welsh barrister, Rhys Meggie, who specialised in criminal and regulatory law at QEB Hollis Whiteman Chambers in London. Guest speakers that night were Eddie Butler and Stefan Rodri. Friday the 2nd, I was able to work on papers at home again. Then the weekend, and the weekend working, I'm afraid, does happen for lots of lawyers. Saturday the 3rd, probably spent half the day working on paperwork at home. Sunday the 4th, again, half a day of urgent paperwork at home. Monday the 5th, a telephone conference in a clinical negligence case where I act for a Welsh local health board, and the young male claimant suffered a hematoma in the top of his right thigh while on warfarin, a blood-thinning drug. Tuesday the 6th, yesterday, I had a telephone hearing before a High Court judge in Cardiff, a highly contested application in a case concerning allegedly negligent treatment of a man who was found by his wife flat on the floor. In fact, he'd fallen and injured his neck. I act for him. There are 5 defendants, 1 local health board, the Welsh Ambulance Trust, and 3 general practitioners. And the allegations are that they essentially negligently manhandled him before taking him to hospital. 3 QCs appeared on the other side for the 5 defendants. There was a fiercely contested application by me to rely on further expert evidence introduced fairly late in the day. My client is now paralysed from the chest down, and the key issue in the case, which comes to trial next month, is whether he was made worse by the negligent manhandling. So today, speaking to you, obviously I've made the trip down to Cardiff. Tomorrow is a deadline for a position statement I've got to produce for a mediation next week regarding performance of clinical trials, and also I've got a roundtable meeting in a claim by a brain damaged child arising out of circumstances surrounding her birth. In that case, I act for the defendant NHS Trust. And then Friday, 2 more case conferences in clinical negligence cases. So that's a feel for my diary and the way it works. Do I enjoy what I do? Yes, very much indeed. Am I privileged to do what I do? Hugely privileged, because it really does give you a great insight into people's problems, people's lives. A lot of being a lawyer is about problem solving. If you've got that kind of mind that enjoys problem solving, enjoys meeting new people and acquainting yourself with new sets of facts, and really juggling lots of cases in your head at the same time, then this is the profession for you. In terms of other ways you can familiarise yourself with life as a lawyer, there are various TV series. Most of them don't quite get it right. Most of them make the court scenes look far too dramatic, far more dramatic than they actually are. But you can always find something to watch on All 4 about the law, I suspect. Books as well. Quite a few humorous novels written about the law. The John Mortimer Rumple and the Bailey series may seem a bit dated now, but they are good stories, and you can enjoy reading around the subject should you be interested in studying it later on. People often ask, what's your most memorable case? I'm not sure there is a most memorable case. Actually, lots of the cases I did when I was a very junior barrister are the ones that stick with me more, because I can remember, for example, getting a phone call on a Friday afternoon from a solicitor I'd never heard of before, asking if I could help with a case for a cheesemaker whose cheese had been banned by the government under an emergency control order. And I didn't know anything about the subject, hadn't really encountered emergency control orders or food safety before, said yes, I could help. A great case, ended up going to the Court of Appeal. You may be able to see here my red bag. We carry our wigs and gowns around in these bags. You can't buy a red bag, you have to be given it by a QC who leads you when you're a junior. And I was given this red bag by my leader in the cheese case, David Foskett QC, now Mr. Justice Foskett, to thank me for my help in the case. They can be embarrassing, these bags, though. Often you stick them over your shoulder when you're coming out of court. I remember once going to Pret-a-Manger sandwich bar opposite the High Court, mid-December, and the Spanish guy behind the counter saying as I walked up, "He's Christmas father." But the red bags you'll see sometimes people carrying railway stations around the country. Our wigs, people always ask about the wigs, made of horsehair, not very comfortable to wear, and as you'll see, not at all flattering. That's rather lopsided, going the wrong way, but really very unflattering. You occasionally get the chance to take them off if it's a very hot day and a judge says you can take your wig off. But interestingly, in the work I do now, many judges say, I'm not going to robe for civil trials, so I don't get to wear my wig that often. Wigs and gowns are still worn all the time in criminal trials. Well, I've spoken, I think, probably for quite long enough. There may be some questions that have come in, and so I'm going to ask Gareth to ask some questions.
If I can come in there, Richard, so they can see my wonderful looking face as well. Yeah, there's not many questions coming on the chat, but we've had some coming on the actual Ask at Careers Wales thing, so I'll go with those. We've got a question here. What percentage of females enter law now, and do you see it as a more balanced employer now?
It is much more balanced. As I think I said, those entering the bar now, it's about 50-50 female male. I think actually for solicitors, I think the percentage is slightly more females than males entering the solicitor's profession. So the balance is there. The key issue is retention of good practitioners as their career goes on. And certainly in the past, it was an issue that lots of chambers weren't so geared up with good maternity and paternity policies, and so retaining people when they had families, because this job can involve you in travelling around the country at fairly short notice, and so you have to have that a bit of a safety net somewhere at home sometimes. And so I'm very pleased that my chambers has been really in the forefront of developing strong maternity policies, and for a certain period of time, until two of them left to become High Court judges, we had the most female QCs of any chambers anywhere in the country. So it is a lot better now than it was. Could more be done? Yes, and it is still being done. But attitudes have certainly changed, and I very much hope that we will have a 50-50 ratio among the bar as a whole in the very near future.
Excellent. There's a few more. Are the public allowed to go into court to observe from a gallery? And I would add to that, really, if they can, so I don't know the answer, but if they can, would you recommend that? If they're interested?
Yeah. Yes. If it's a public hearing, then members of the public can go and sit in the public gallery. Some hearings are held in private, but that's always advertised on the door of the court. You're hearing in private, you can't come in. So as long as you're 14 years old, you can go and sit in the public gallery and watch what's going on. And I would recommend it hugely. It gives you a great insight into actually what does go on in court, the pace of things in court, the relative absence of drama most of the time in court, but also the way in which the lawyers do their job, because they have to wade through a lot of information and really have to make sure that they are on top of all that information and ask only the relevant questions. And judges, you'll see at work as well. Judges are drawn mainly from the barristers and solicitors professions. And so sometimes people decide at a point through their career they would like to be a judge, whether a circuit judge or a high court judge or district judge in the magistrates court or in the county court. And again, you apply for this. It's competitive application, as with all these things now. And if you get through, then that will be a full-time job. You're actually employed then by the Ministry of Justice, and you receive a salary. In terms of the ages people start thinking about applying to become judges, I think very recently a full-time circuit judge was appointed who is 37, which is pretty young. In the new QC ceremony a week last Monday, there was a 34-year-old QC, again, very young indeed. Most of the time, people are thinking about applying to become judges in their 40s or 50s, but it does vary hugely.
Excellent, and we've got some good questions coming in now. So thank you for the Year 10 student that asked this. Is it beneficial to have a second language?
I think it's always beneficial to have a second language, whatever you do. Yes, if you're looking at the Welsh example for a moment, litigants have a right to contest their cases in the Welsh language in the Welsh courts. And so in chambers in Cardiff, Swansea and Chester, there is a demand for Welsh-speaking barristers, and certainly it's a great advantage you've got that. In terms of other languages, I love my languages. I studied languages originally, but I get very few opportunities to use my French and Spanish in court. I think I can remember one case when I was defending a chiropractor in the General Chiropractic Council, and the complainant was Spanish and had some recent treatment in northern Spain, and produced some notes in the course of her evidence which were in Spanish only and hadn't been translated. And thankfully I was able to cross-examine her on the basis of my translation of those notes, but that almost never happens. But what I would say is that learning another language always improves your own English, and any improvement of your English will be a great help to you in a legal career, because the drafting of documents and precise language is a very important part of any lawyer's job.
Excellent. Double-sided question here. So there's two parts to this question, and thank you, Alistair, for sending this question in. Do you ever find yourself influenced by merits of opposing side in court, and how difficult is it staying focused on the advocate for your client in these circumstances?
That's a very, very good question indeed. There are some cases when you go to court and you know you've got a strong case, other cases when you go to court and you know you've got a weak case. Many cases settle before you get to court, and going to trial in civil claims is a notoriously uncertain business, because usually you only find out which judge you're going to draw to try the case on the afternoon before the trial starts. So if you're starting a trial on a Monday, you find out Friday afternoon which judge you've got. And some judges are more friendly to claimants, some judges more friendly to defendants. Yes, of course, you analyse the case in advance and you try to work out where the strengths and weaknesses are. But you certainly do, at trial, appreciate the merits of the other side's case. But that doesn't stop you from being as forceful and as fearless an advocate as possible for your own client, obviously within the limit of your instructions from that client.
Excellent. I'm so glad we give 15 minutes to the questions, because they're coming in thick and fast now. Next one is from Sheila, who is the careers advisor at Dufferin in Port Talbot. Thank you, Sheila, for hopefully it was a student's question, but it could be yours, because obviously you need to know as well. Are there equal numbers of female barristers to male barristers?
I think there's a point we were covering just now, not quite equal yet. About 16,000 barristers in private practice, and about 6,700 women of that 16,000. So a little bit to go to get to 50-50, but very much getting there in terms of recruitment into the profession now. So yeah, we're definitely getting there.
That's good news, though, isn't it?
Absolutely, yes. And also
compared to other sectors,
it's striking that now we have a female president of the Supreme Court, Baroness Hale. Baroness Hale, first female president of the Supreme Court. She has not had a traditional route to becoming a judge. She was an academic, and so came through that way to becoming a judge. Of the last 3 members of my chambers who've gone to be High Court judges, 2 have been women. And so, yeah, it is definitely happening, but it's still taking some time.
Okay, Shan in Bishopston School in Swansea. Can solicitors go on to train to be barristers? Yes,
and increasingly, because of the difficulties of obtaining pupillage, some people are choosing to qualify as a solicitor first of all, perhaps practice as a solicitor for 4 or 5 years, and then to apply to the bar at that point. Because after working for 4 or 5 years as a solicitor, you may have developed a specialism which may make you more marketable to a set of barristers' chambers. So yes, that is very much a way to do it. Some people think you have to be a solicitor before you can be a barrister. That's not true. You decide, in effect, when you're at university, which of the 2 routes you're going to pursue. But I think it's probably fair to say that there are some barristers who convert to become solicitors, and some solicitors who convert to become barristers, and some barristers actually work as employed barristers within solicitors' firms now.
Okay. A question here from Julie, a very interesting one as well, and probably pertinent to most of the students listening at the moment. The first thing that comes is the Ledlet scholarship.
Yes.
For most of those students. Is there any top tips you would give to anyone applying for the Ledlet sponsorship?
I think the importance, the really important thing when applying for any scholarship is be yourself. Be yourself on paper. Don't try and paint a picture of someone else. Be absolutely scrupulously honest. Tell them about you, warts and all. Ledlet exists to prioritise those from non-traditional legal backgrounds, and so it really is there as an opportunity for someone who might not otherwise have had the opportunity to go to London to see the law at work, for them to see the full picture in a week. So just put down all your qualifications, all your good academics, all your extracurricular activities, but just give a bit of yourself and give a bit of your enthusiasm for the law, why you are actually keen to pursue a legal career, because that will help.
I remember, Richard, meeting your colleague, Mr. Samuel, around about 4 or 5 years ago now.
Yeah.
They were trying to get the scheme off the ground, and I've worked closely with the secretary at Ledlet. Way back then, it was said that we wanted to highlight to students in Wales, the benefits of being a lawyer and a barrister and in the law in London, but B, to try and highlight to those students who perhaps never thought that they could, aim high, if you like.
Absolutely.
And not necessarily, them students in school that never thought of law or had role models to push them in that way. Is that still the...
Very much, Gareth, very much. There is no blueprint for a future solicitor or a future barrister, and you don't have to be getting all A's age 14 in order to be a solicitor or barrister in the future. As I said earlier, we all develop at different rates, and if you can show tenacity, enthusiasm, real desire to pursue the career, and as long as you actually make the academic grade in the end, you will have a good chance of getting through. But I think aiming high is absolutely crucial. I become concerned when careers advisors or school teachers appear to limit pupils' horizons. I think it's really, really important to emphasise that you've got 5 choices on your UCAS form for universities. If you want to have a go for Oxford or Cambridge, it's only one of the 5. It's not a waste, it's worth having a try. And both of those universities are seeking to widen their pool of students, to recruit students from schools they've not recruited students from before. So it is worth a try. It's only one shot out of 5. I had one work experience student a few years ago say to me that her careers advisor had said they should all go to Aberystwyth University. Again, just life-limiting advice. You should aim high. Aberystwyth is a very good university, but look as broadly as possible, and don't be afraid to travel far to go to university, because again, you get different perspectives on life the further you travel from home.
Excellent. Final question there, Richard, because we're running out of time. This one probably double-sided again. Do you prefer prosecuting or defending? And then on the defending side, I suppose, if you've got a slight inclination that this guy could be guilty or this girl could be guilty,
this is
put you on the spot.
This is the question we always get asked. Barristers always get asked this question by everyone we meet, wherever we go. How do you defend them if you know they're guilty? The first part of the question, prosecuting or defending. The only kind of quasi-criminal work that I do, other than as a part-time judge, as a recorder, where obviously I'm for neither side, I'm trying to be fair, but is in the disciplinary and regulatory field, and where I'm typically defending more of the time than prosecuting, defending doctors, vets who've got into trouble in some way and are up in front of their regulator. I very much enjoy defending. I have prosecuted in the past. Yeah, it's okay, but defending is what I would prefer to do in those professional disciplinary tribunals, and on behalf of sports people as well. In terms of the question, if you think they might be guilty, we are creatures of instruction. We take instructions from our clients, and so often the evidence may be overpowering against them. But if they're giving you a version of events, which is their version of events, then subject to it being utterly implausible, you have to follow their instructions. Now, there may be times when you simply say, well, this is so implausible, I cannot put this forward knowing it to be false. In which case you say to them, well, yes, I can test the prosecution evidence to see whether the prosecution evidence meets the required standard of proof in the criminal court beyond reasonable doubt. In the civil courts, balanced probabilities. But I'm not going to put forward a positive case which I know to be false. In those circumstances, sometimes barristers find themselves getting sacked by defendants because they won't do what the defendant wants them to do. But equally, sometimes defendants say, okay, well, if that's the way it is, then that's the way it is. But it can be a difficult ethical tightrope to walk at times. And so it's very important to have a solid ethical compass. But the Bar Council provides very good advice. You can call someone back in chambers if you've got a difficult professional ethics issue, which sometimes crops up at court. Sometimes you feel you're being pressurised by a judge to take a particular course, which isn't in the best interest of your client. And so you have to step back and really be quite independent in your thinking.
Okay, thanks ever so much, Richard.
Pleasure, Gareth.
We're probably going over our time now, but I just want to say a final thing. If somebody's sat there watching now and they think, there's a question pops up after we go off air, is there a way they can come through me?
Absolutely, yeah. Please email Gareth at Careers Wales. I'll happily deal with any queries later on. If anyone has a genuine interest in the law, I'm happy to discuss further with them to try and point them in the right direction. Because I think we can't have enough good young Welsh lawyers coming into the profession. So I wish you all well and good luck. Okay, Richard, thanks ever so much, and I'm sure that's been a tremendous insight for our careers advisors and more importantly our students. To arm them and inform them in going into law. So Richard, thanks ever so much. Pleasure,
and what I'm to ask everybody now when we end the event is you should get an email asking for feedback. Please do feedback. This is Richard's first webinar. It's my first webinar, and we would very much like your feedback. So from both of us, thanks very much for tuning in, and see you all soon. Bye.
Bye-bye.
Thanks so much, both. Really interesting. Thank you all.